A very, very good evening to all of you, friends. A very, very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So, friends, today we begin with another very, very important session on legal practice questions. Today, we bring to you certain very important legal reasoning questions, which is not only going to help for your AILET but also for your CLAT. These questions are of great importance, and by the time we solve these questions, I'm sure that you guys will be in a position of a great confidence. Now, why confidence? Because confidence is only that thing that is going to help you out. If you lack confidence, your examination is not going to go well. But if you do, if you have that confidence in you that yes, you can get through this CLAT and AILET examination, that is all that we want from BYJU'S exam prep. We are determined to help each and every one of you to score better for this examination for the year 2023, be it the 11th of December or the 18th of December. That is AILET as well as CLAT. So a very, very good evening to all of you. A very, very good evening to all of you, friends. Now, in this session, I'm going to discuss with you and will be trying to solve with you certain important legal reasoning question. Okay? Are we all on the same page? Are we all on the same page relating to solving certain important legal reasoning question? So, guys, let's begin with this section on legal reasoning. Okay, so, guys, the first question is up there on your screen. Do not waste much time. The principle and the fact is given on your screen. Please take note of it. Read the principle as well as the fact very, very carefully. Read the question. Read the first question. What does the principle say? Fraud includes the suggestion as a fact of that which is not true by one who does not believe it to be true, or the active concealment of a fact by one having knowledge or belief of the fact which intends to deceive another party. So there is that word, deceive another party or his or her agent to enter into a contract. That's all. Read it carefully, all of you. Let's read the facts. Wind-On Limited, a leading manufacturer of wind turbine to harness wind energy to produce electricity. It is based out of Nagaland in India and has been manufacturing wind turbines since 1990s with national and international fame. Z Infrastructure Limited is a leading infrastructure firm with a proven track record in building energy installation and highway across India. The fact talks about fraud. It talks about deceiving another party for a contract, and the facts is given. Let's read. Z Infrastructure wanted to expand its portfolio and operate in windmill park to supply clean energy, clean electricity. Representative from Winden and Z Infrastructure carried out extensive negotiation advertised by leading law firm and commercial advisory firm on both sides for the later to establish wind park in Orissa. Z Infrastructure wanted wind on to guarantee that the turbines will generate 54 lakhs kWh, kilo megawatt of energy per turbine annually. Windon stated that the position was the generation of energy is independent on availability of the wind, and they do not guarantee on it. They do not guarantee on it. However, they provided an estimate that the contract for supply of turbines, that the turbines will be able to generate around 50 lakh kWh per turbine annually. The turbines were supplied by Windon and operated by Z Infrastructure in Orissa for over 2 years. That is all that we have in our facts. Is that clear? Everyone. The principle of fraud is given. The facts says that somebody wanted 54 lakh kilowatt hours, and the other company says no. It depends on the wind. It depends on the wind. So approximately around 50 lakh kWh per of turbine annually will be provided. Okay. Let's read the question. The output that came, that was around 35 lakh kilowatt annually. They were frustrated as the actual generation of the turbine was significantly lower than the generation estimated provided by the Windon. They reached out to Lal and Company, a leading dispute resolution law firm, to understand if they could initiate action against Windon for fraudulent representation of generation estimation of each turbine. Now, they wanted 54, an approximate of 50 was given. The resultant came to 35, right? Now, the question is, had Windon committed fraud by providing an inflated energy generation estimate? The question is that. The question over here is, has Windon committed fraud? Yes, let's see. Did they provide any sort of guarantee? Somebody said, okay, I want 54. They said that, okay, it depends on the wind, but approximately you might get around 50. And the resultant was 35. And the resultant was 35. Am I clear, everyone? So, the correct answer to this question, let's see that. Let's see that. Okay. Okay. I am getting a couple of answers. From you guys. Let's see the correct answer up there on your screen. Okay. Sumit Dash says B. Okay. Alifia says B. Yeah. Okay. The correct answer is definitely no, as Windmill clearly specified that the energy generation is merely an estimate and could not provide a guarantee on it. So the correct answer is option B. Option B is the right answer, guys. Option B is the right answer to each and every one of you. Is that clear? Is that clear to each and every one? Is that clear to each and every one of you? Is that clear to each and every one? Okay. So the correct answer is option B. Let's move to the next question. Question number 2. Okay. So a bailment is the delivery of goods by one person to another for some purpose upon the contract that they shall, when the purpose is accomplished, when the purpose is over, the goods are returned back to the bailer. Principle number 2. In all cases of bailment, the bailee is bound to take as much care of the goods bailed to him or her as a person of ordinary prudence would under similar circumstances. Take his or her own good of the same bulk, quantity, and value of the same good bailed. Facts. This is the facts. Aparna entered into a contract with Gagan to keep her goods in the warehouse until she is able to find a suitable buyer for them. Am I clear? Please read the first principle. These are the two principles given, and then the facts. Okay, are we done? Are we done? Let's read the remaining part of the facts. Gagan kept his own goods in the same warehouse. One night, certain thieves entered the warehouse and stole the goods of both Gagan and Aparna. It was discovered that even though Gagan had locked the main door, he had carelessly left the window open, and that the thieves had entered through the open window. Aparna sued Gagan for damages as Gagan had failed to take care of the goods. Now, under the principle, if you read the principle very carefully, it says that if you have given certain goods to me, I should take care of the goods as if it was my own. But I have carelessly left the window open and the thieves entered through the window. Thieves entered through the window. Am I clear, everyone? Okay, let's see. Is Gagan liable or is Gagan not liable? Now, suppose you give certain goods to me under bailment and I keep those goods under the same precaution as I would have taken care of my own goods. But I left the door key open, I kept everything open. Now, in such a situation, very good. Okay, Alifia says A, very good. Gagan is liable. Since he had kept the window open and showed that he did not take care of as a ordinary prudent man would have taken care of his goods. So the correct answer over here is option A. Option A is the right answer to this particular question, guys. Is that clear? Everyone? Every one of you. Okay, let's move on to the next question. Question number 3. Okay, yeah. Question number 3. Yeah. Read the principle and the facts. Very simple. Commission, intention and preparation is not a crime. Attempt and commission is punishable under law of crimes. In order to be designated as an attempt to commit an offense, the act or series of act must be sufficiently proximate and accomplished of the intended offense. Sachin brought a matchbox, lit the matchbox near the haystack. It was brought to light the haystack and on fire and committed the offense of arson. However, before he could do the same, he realized that someone was secretly recording a video of him. Fearing that he would be easily caught, he extinguished the match. Sachin is prosecuted for attempt to commit arson. What is the correct answer? Did he? Now, he did light the match. Now, when he saw someone videographing him, when he saw someone, with his mobile phone videographing that thing, he extinguishes that. Does it not mean he did try to burn? Did he commit an attempt? Did he commit an attempt? Yes, he did. So the correct answer is option B. Sachin is guilty for having committed attempt to arson. Is that clear, everyone? Every one of you. Okay? Is that clear? Is that clear? Sorry. My bad. Bringing the matchbox and the lighting has a sufficient proximity which the intended offense of arson, and therefore Sachin is guilty of committing attempt to arson. There was an attempt. Is that clear? Let's move on to the next question. Question number 4. The principle of double jeopardy. Nobody shall be prosecuted twice for the same offense. Let's read the facts. Arun was a government employee working with the Examination and Admission Department of Indian Institute of Science and Technology, the best engineering college in India. Arun is accused of having leaked the examination paper to Kamlesh for a hefty bribe. Disciplinary proceedings were initiated against him. He was found guilty, and as a penalty, he was removed from employment. Thereafter, a criminal case was registered against him for committing the offense of cheating, leaking the examination paper. Arun takes the defense that the criminal proceeding is not permitted by the principle of double jeopardy. So you have number 1, a disciplinary proceeding. And number 2, you have a criminal prosecution. Right? You have a disciplinary proceeding. Disciplinary proceeding was initiated. He was found guilty and he was thrown out of that college, university, whatever it may be. Now he is prosecuted under criminal law. Is it a question of double jeopardy? Will the principle of double jeopardy be applicable? Tell me, all of you. And the correct answer is that the principle of double jeopardy. Now, option C is not correct. No. The correct answer is the principle of double jeopardy will not apply as the disciplinary proceeding is not termed as a prosecution. Now, disciplinary proceeding is not a punishment under the law. A disciplinary proceeding cannot be termed as a punishment under the law. A law can punish you under civil law or criminal law. Disciplinary proceeding is by the university itself. So the correct answer is option A. Am I clear? Every one of you? Disciplinary proceeding do not qualify as the term called prosecution under the law. Is that clear, everyone? Is that clear? Let's come to question number 5. Let's come to question number 5. The principle is given and the facts is given. Nuisance. Unreasonable interference with someone's use of the land and enjoyment of the land. That's it. The village of Zandipur had a century-old cricket ground which was owned by Zandipur Cricket Club and hosted match between local teams every week. It is the only sport ground in the village and serves as a critical source of recreation for the village. Mr. and Mrs. XYZ purchased a home right on the edge of the cricket ground boundary. Balls from the cricket match frequently fall into their residence garden and it caused severe damage to their windows. They have unsuccessfully tried to request the cricket club to install nets around the park of the boundary that is adjacent to their home. They seek to claim nuisance against the cricket club. They are now wanting to seek certain type of nuisance, a claim of nuisance against the cricket club for banging their doors, windows, whatever it may be. Okay? Are we all understanding this? Did we all understand the present facts? Okay? Okay. Now, I think there is one slide that is missing. The answer is knowledge of the cricket ground in the neighborhood will not amount to accepting nuisance every day. It will be amounting to nuisance. It will amount to nuisance. It will amount to nuisance, guys. It will amount to nuisance. It will amount to nuisance. There is no doubt about it. Am I clear? Then here is a situation. Will it amount to nuisance? Yes, it will amount to nuisance. Because there is severe damage to the doors and the windows as per the facts. Cricket club will be held liable for having committed nuisance. Am I clear, all of you? So these are the kind of questions that you might get in your examination. Okay, you might get. So it's better that you understand these questions clearly so that you do not falter while answering on 11th as well as on the 18th of the next month, that is 18th of December and 11th of December. Is that clear, everyone? Now, before moving ahead, it's now or never. Most expected question series to ACE, CLAT and AILET. Join us on 5th of December onwards at 7 p.m. and 9 p.m. daily. BYJU'S Exam Prep brings to you a 6-hour non-stop marathon. A 6-hour non-stop marathon on the 4th of December between 11 and 5 p.m. Current Affairs by Abhimanyu Sir, English CR by Krishnendu Sir, Quant by Ankur Sir, and Legal Reasoning by myself, Shurojit Bhaduri. Okay, so never miss this particular session. Do not miss this particular session. We are going to cover all the subjects, complete revision, and practice important questions on 4th of December 2022. Okay, let's move ahead. Okay, to the next question. Let's read the principle and the facts. Solely on the instruction of the Queen, a police officer secretly entered Mr. A's residence to search through her computer and discovers her plan for the protest. However, A's laptop was at the repair shop and the police officer was forced to exit Mr. A's house after a few seconds. Mr. A seeks to sue for trespass. Is the Queen a judicial officer? That is a question that has been asked. Is the Queen a judicial officer? The Queen. Now, the principle over here that is specifically given is by an authorization by a judicial officer. Authorization by a judicial officer. Is the Queen a judicial officer? No. So the correct answer is option C. Am I clear? Am I clear to each and everyone? Is that clear? There is nothing in the facts to indicate that the Queen qualifies as a judicial officer. That is the answer. That is the precise answer. Okay. Moving on to question number 7. P entered into an agreement with Q, which mandated that Q can only sell the lamps to the store at the minimum retail price of 50, failing which Q would have to pay P 5 for each lamp sold below 50. Okay. P, Q, and R. P, Q, and R. Okay, okay, okay. Okay. Done? Are we done? Privity mandates that only parties to a contract can sue each other. Only parties to a contract can sue each other. So if there is an agreement between A and B, only A and B can sue each other. C, who is an outsider, cannot sue. Very good. The correct answer is A. Pay will not be successful since there was no privity of contract between P and R. Was there any privity to contract between P and R? The correct answer is no. There was no such thing. P and Q, yes. Since there was no contract between P and R, P will not be successful. P will not be successful. Is that clear? Question number 8. So, guys, are you understanding how to solve these questions? Okay. Yeah. Let's read the options and tell me which of the following is the correct answer. Is K competent? Is K not competent? Hariom says B. Alifia says B. Okay, B, 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 B. All B. Let's see. Let's see the facts. Now, K was a minor. Very, very important. K is a minor. 2 days before K completed 18 years. 2 days before. 2 days before he completed 8 years. K really liked his offer. He entered into a contract of sale to Z. Am I clear? The correct answer is option B. Very good. Because K had already completed 18 years. After 2 months, he entered into that contract. Very good. Very good. Very good. Very good. Moving on to question number 9. Jay did not pick up her phone. Jay did not pick up her phone. Is that clear? The phone was never picked up. The phone was never picked up. Very good. The correct answer is D. J will be unsuccessful since T's acceptance had not been communicated to constitute a binding contract. Very good. Very good, all of you. That's the answer. Option D. Is that clear, everyone? Option D happens to be the right answer. Let's move on to question number 10. Very simple. Let's come to the options. Let's come to the options. Let's see the correct answer. Alifia Debadrita. Okay. The correct answer is option C. The principle requires that both the parties must be under a mistaken belief. In this case, L was aware of the destruction. L was already aware that there was a destruction of the subject matter. Hence, the rule is not applicable. Is that clear, everyone? Moving on to the next set of questions. Before we move on, it's now or never. Most expected question series to ace AILET and CLAT 2023. Join us on 5th of December onwards at 7 p.m. and 9 p.m. daily. Watch it on our YouTube channel. BYJU'S Exam Prep brings to you a 6-hour non-stop marathon on all subjects. Complete revision, practice important question on 4th of December between 11 and 5 p.m. So we have a 6-hour long marathon going on the 4th of December, a live session on our YouTube channel. Okay, so do join us. Moving on to question number 11. Both parties to a contract are discharged from their respective outstanding obligation in situation where a supervening event happens. Act of God. In the city of Victoria, a high susceptible to public health arises. F. A supplier of raw food materials entered into a contract with H for 2 years, whereby S would supply certain raw products to H at a predetermined price. Their agreement also provided that in case, very, very important, read this part. In case of interruption of operation of H on account of epidemics, pandemics, or any other public health crisis, the contract will be suspended until the crisis is declared to be over by the government, and thereafter, pending contractual obligations shall resume. 3 months were left for the contract. They were at a highly contagious virus outbreak in the city, which causes the restaurant owners to suspend operation. Once the outbreak was declared to be over, 6 months later, H refused to purchase raw materials from S, arguing that he has discharged his obligation under the contract. Am I clear? Everyone, read it out. It's very similar to the coronavirus pandemic. The options. Now, the correct answer is H has not discharged from his obligation because the contract contained a provision dealing with outbreaks. Further, the parties could have reasonably comprehended the occurrence of an outbreak. So, the correct answer is option B. It's a direct application of the principle on facts. H has not discharged his obligation. Very good. So, I'm sure that right now, when I see your answers on the chat box, I feel that you guys are in a position where you can and you will be able to solve these questions very easily. Moving on to the next question, question number 12. When a defendant brings on his land anything that is likely to do mischief and it escapes, they must do so at their own peril. If such a thing does escape and cause forcible harm, then the defendant is liable for damage caused provided that the land from the escape occurs has been changed such that it would be considered to be non-natural use of the land. Non-natural use of the land. The defendant can avoid liability if they can show that the situation that caused damage was a result of an unforceable act of a stranger which could not be controlled by the defendant. M decided to keep a tiger as a pet on his to that end. He brought a caged tiger to his house. Jealous of M's pet, M's neighbor S decided to break into M's heavily guarded house while M was away, opened the tiger's cage. The tiger escaped, mauled pedestrians near the house. The pedestrian wished to sue Mr. M. Is that clear, everyone? So, guys, if you are liking this session, if you are understanding how to solve the questions, do press the like button. Do share this session with your friends who all are also preparing for CLAT and AILET for the year 2023. Let's move on to the options. Let's see the answer. Can M escape liability? Yes, because it was caused by an unforceable act of a stranger, which could not have been controlled by M. Absolutely correct. This is bang on from the passage itself. The principle itself says certain facts, right? So the correct answer is the tiger harmed the pedestrian because of unforceable act of a stranger. Is that clear? Is that clear to each and every one of you? All of you. Okay, moving on to the next question. Question number 13. The principle and the facts. Agreements, the meaning of which is not certain or capable of being certain, are void. Nayak wanted to buy a motorbike to reduce her waiting time for her daily commute to work. She can pay up to 35,000 for a second-hand motorbike. But Nayak agrees to sell a certain purchased Honda motorbike for 31,000 or 30,000. Yeah, yeah. So that is a principle and this is the facts. Okay, am I clear, everyone? Yeah. Somebody wanted to buy a bike for 35,000, somebody is willing to sell it. Now, are there meeting of minds? Are there any meeting of minds? An agreement happens when there is a meeting of mind, consensus and item. Right? So the correct answer is the agreement is void for uncertainty, since there was nothing to show that the two parties have finally agreed. Nothing to show in the fact that both the parties have agreed to the same thing in the same sense. Am I clear, everyone? Am I clear to each and every one of you? If you have understood it, just press the like button. Is that clear? Okay, let's move on to the next question. Question number 14. The principle and the facts. Nayak wanted to buy a motorbike to reduce her waiting time for a daily commute work. She can pay up to 35,000 rupees for a second-hand motorbike. Now comes the difficulty. Dev and Ela agrees that Ela will initiate a pay of 31,000 to this motorbike, and if the mileage given by the motorbike exceeds 60 km per liter on an average for 5 months following the scale, Ela will pay an additional sum of 33,000 rupees. Is it a valid agreement? Now, when you are agreeing to certain things, either you agree, you cannot use terms and conditions. Now, is the agreement valid? Let's understand. He says below 35,000, he says 30,000. Let me see. All of you. All of you. Now, The correct answer over here is the agreement valid or invalid? The agreement is invalid. The answer is given wrongly over here. Option B is given. I will not say some error over there. The correct answer is option D. Is that clear? If you want to agree, you agree in toto. If you don't want to agree, you don't agree. Is that clear? Is that clear to everyone? This is the wrong answer that is given. Wrong answer is given. Okay, wrong answer. The correct answer is option D. Next, let's move on to question number 15. Damages consequent to a breach of contract seek to compensate the innocent party for the loss suffered by it so that the innocent party is put to the same situation with respect to damages so far as money can do it, as if the contract has been performed. Facts. A agrees to sell 30 kilos of strawberry to B, knowing that B uses the strawberry to run his juice center. B's Juice Center is located at St. John's College near Delhi University, very popular with students. A supplies substandard quality of strawberries to B. However, B is able to use the strawberry for the juice center. None of the customer of B is able to make out the difference or complain about the same. For the matter, face or any issue after drinking the juice. Can be recovered damage from A? The question is there. Are we done? Are we done? Read the passage, read the principle and the facts very carefully. Okay, let's see the correct answer. Was there any violation of his legal right or was there any loss? Was there any loss that was suffered by the juice seller owing to the substandard strawberry? Tell me, all of you. And the correct answer, most of you, yes, A is not liable to compensate B since B suffered no monetary loss. Absolutely correct. There was no loss, no evidence of any monetary loss to B. There was a smooth functioning of the business. So, the correct answer is option B. Am I clear? Everyone. Is that clear to each and every one of you? Guys, most expected question series to ace CLAT and AILET 2023 will be there on our YouTube platform between 5th of December every day on at 7 p.m. and 9 p.m. So join us on 5th of December onwards between 7 and 9 p.m. on our YouTube channel for the most expected question series to ace CLAT and AILET 2023. BYJU'S Exam Prep brings to you a 6-hour non-stop marathon. A 6-hour non-stop marathon on all subjects. We shall be doing a lot of revision on all the subtopics of law, quant, English, and current affairs. And more precisely, we shall be solving practice questions. By Abhimanyu sir will be there, Krishnendu sir will be there, Ankush sir will be there, as well as myself. Okay, Shurojit. So do join us on 4th of December between 11 a.m. and 5 p.m. for the 6-hour non-stop marathon for CLAT 2023. Is CLAT and other law exam with BYJU'S exam prep test series, which brings to you 45 mocks, 20 CLAT, 25 non-CLAT, 9,000 practice question topics, test covering every single subtopic, 3 All India mega mock with video solutions, detailed mock analysis, test series which are curated by NLU alumni and which are based on actual exam pattern. BYJU'S Exam Prep brings to you the last lap to CLAT 2023 25 Power Pack session, must to do topics, practice question based on exam pattern, paper solving skills and tips starting, and it is already there on our YouTube platform. So definitely go through these last lap to CLAT 2023. Do subscribe and press the bell icon of BYJU'S Exam Prep YouTube channel. Follow us on our Instagram. Do like our Facebook page. Do join us our Telegram channel. And do not forget to download the BYJU'S Exam Prep app. Get it on the Google Play. Link is given in the description below. So I hope that today's class was a nice class for you. You understood certain very important question. You did solve certain important question. Thank you very much. God bless you. Bye-bye. Take care. Have a great week ahead. All the best for your CLAT. See you on 4th of December with the marathon session. Thank you. Bye-bye.